the East Coast, and good morning. If you're far enough out west, you are listening to the Higher Education Regulatory Outlook for 2023, which is part of Thompson Coburn's Higher Education webinar series for the year 2023. We're here already, hard to believe. While folks are jumping on, I'm going to go ahead and get into some quick housekeeping. First of all, on and around the platform here, you'll see there are a number of widgets. If you have any questions during the webcast, you can submit them through the Q&A widget at the bottom of your screen. We will try to collect all those questions, and then we'll plan to answer questions at the end to the extent time allows, and we do hope to have time to be able to do that. A copy of today's slide deck is available in the resource widget. I believe that's true. As is often the case when it comes to presentations of this particular type, we are working on the slides right up until the end, but I think they managed to get them into the resource widget. If for some reason you cannot get a copy of the slides, you are welcome to just reach out to me, and we will make sure that you get a copy. We want you to have them. You can find additional answers to some common technical questions located in the help widget at the bottom of your screen. This is, like most of our webinars, this webinar is approved for continuing legal education credit, or CLEs, in California, Illinois, and Texas for an hour and a half of general CLE credit, and in Missouri for 1.8 hours. So if you're an attorney and you're looking to get that CLE, you can do it. The webinar is also CLE accredited already in New York for 1.5 hours of experienced in transition credit. We award CLE based on attendance for the entire 90 minutes. So if you are an attorney looking to get CLE, please make sure to hang in there. And due to jurisdictional requirements, you'll see that we are no longer doing the automated pop-up attendance checks. Instead, we're going to do 3 secret words during the course of the presentation. And you'll need to be watching when those secret words pop up and make sure that you hit the correct radio button. Finally, as is always the case, we have a post-webinar survey, and we are extremely and deeply grateful to anyone who takes the time to fill out that survey. I say it every time. We always look at the feedback, and we always try to make each presentation better than the one before. So if you have a minute, we would love to get your thoughts. Thompson Coburn, if you don't know, if this is the first time you've tuned into one of our webinars, we are a law firm. So I'm an attorney. I'm the chair of our higher education practice, and we have a number of attorneys here at the firm who spend either all of their time or a significant portion of their time serving institutions of higher education, and in some cases, vendors, businesses, companies that serve institutions of higher education. We have a little over 400 attorneys, so we're a fairly big firm, and we have offices around the country. My name is Aaron Lacey. I mentioned I'm the chair of the higher education practice here at Thompson Coburn. Been doing this for a little over 20 years, it's hard to believe, and work with institutions on a wide range of what I'll call sort of legal and regulatory matters. But a big part of what I do in particular is think about what's going on inside the Beltway, and in particular federal higher education policy. And that, of course, is the focus of today's webinar. Speaking of which, here is our syllabus. We're going to start with a brief checking in of the checks and balances and what this is really about, just to set the stage. You know, we're talking about the department's regulatory agenda and all the things they're trying to accomplish. And I think it's important to understand, at least briefly and to some extent, the dynamics at play in Washington, because that helps inform the understanding of what is happening and likely to happen on the regulatory and policy front. Then we'll talk about the status of the department's Title IV rulemakings, meaning all those regulations that are carrying out Title IV of the Higher Education Act. Federal financial aid is typically what we think about there. And then we'll talk briefly about the status of some of the department's other rulemakings, meaning non-Title IV. I want to talk a bit about sub-regulatory activity, the stuff that the department is interested in doing that's not occurring as part of the rulemaking process. And then at the end, you know, I didn't want to just dump a whole bunch of information on you. I wanted to try to give you a little bit of sort of practical advice and some thinking around, you know, what you as an institution or someone who is in this space can do, because I can assure you, if you are paying attention, then you know that right now we are in a period maybe of the greatest regulatory activity from the department, at least in the last 25 years. You know, it's really incredible how much is occurring at the moment, how many new rules and policies are being contemplated and promulgated. And if you feel like you're drinking from the fire hose, you are not alone. Those of us that do this all the time feel that way as well. It's a real challenge. And so the question becomes, you know, as you're trying to manage this deluge, where do you put your focus? Because we all have limited resources and time, and there's always the question of, how do we sort of parse through all of this and figure out what makes the most sense to try to deal with first? And so I have a couple of suggestions for you. This is certainly not a comprehensive review of all the different regulations, just conceptually some ideas where you might try to focus your attention as over the next 12 to 24 months, you continue to try to absorb and process all of the new regulatory information that's coming your way. Okay, so let's start with the checking the checks and balances. You guys know this stuff. This is from your civics course in junior high, right? So we've got Congress up there with the statutes, and then we've got the executive branch. That's our president and all those agencies, including the U.S. Department of Education. And their job, conceptually, is to take the directions and the laws from Congress and to execute on them. And sometimes that involves creating new regulations or otherwise promulgating guidance, et cetera. And then we've got the courts over there sort of keeping everyone honest. And when it's working, this is kind of what it's supposed to look like. Again, Congress creates the statutes, and then the president and the executive agencies carry out those statutes and directives and programs and add to them by creating regulations and then sub-regulatory guidance in the way of electronic announcements and dear colleague letters and all those kinds of things. And when things go awry or someone thinks an agency may have overstepped or even Congress may have overstepped, you may end up in the courts. This is when things are working correctly. The challenge we've had is that over the last 20 to 30 years, and it's never a perfect system, by the way. So, if somebody tells you back in my day it was perfect, that's not true. There's never been a time in American history where all of that worked perfectly. But we are in a period of sort of particular dysfunction, right? I mean, over the last 3 decades, there's been a significant decline in what I'll call the legislative success rate. If you look at this little graphic on the right, in the late 80s, of all the legislation that was being introduced in Congress, about 6% was becoming law. What's interesting is the number of bills and pieces of legislation being introduced has gone up, but the percentage of that is actually getting across the finish line has gone down significantly. And this is not something that's news to most of you. I'm sure you're seeing this at the top line of the daily press, that Congress is having trouble getting things done. That's not to say they get nothing done. Actually, if you go back, they have had some successes in the last few years. But on the whole, they've been tied up in largely in gridlock, right? And so what happens as a product of that to try to move things forward is, you get a White House and executive agencies that are trying to use other tactics, right, to try to advance their agendas. So we've seen an increase in executive orders across the last 3 administrations, significantly across the Trump and Biden administration, right? We've seen increased activity from executive agencies themselves, like the Department of Education, and we see that in the form of rulemaking and trying to create law through enforcement actions, in a sense, right? So, for example, during the Obama administration, it was almost nowhere the case in law that discrimination based on sex included discrimination based on gender. That just hadn't made its way into legal text yet. But the Obama administration started directing the EEOC and other agencies in enforcement actions to start interpreting the law that way. And so they were advancing their policy outside of any directive from Congress, or in that case, even any new regulatory text, right? And then you have sub-regulatory guidance. Again, Title IX is a great example where the Obama administration put out several very critical Dear Colleagues letters that really shifted the Title IX landscape, and yet none of that was actually new law. It was the Trump administration that, dumped all of that sub-regulatory guidance and created the first new Title IX rule. So we have lots of examples of this kind of activity, including at the U.S. Department of Education. And of course, when you have regulatory agencies and an executive branch that starts trying to advance policy without the backing of Congress and sometimes without even going through the Administrative Procedures Act and rulemakings, then you end up with more multi-state attorney general lawsuits, nationwide injunctions, and as a product of that, then we get folks who are taking all of this up to the Supreme Court, and you have the Supreme Court sort of rethinking the extent to which agencies can make rules without appropriate authorization and direction from Congress. So it's interesting when you have a Congress that is dysfunctional, it sort of throws the whole system out of whack in a sense, and you start seeing all these different machinations down the line, and that's where we are right now. I bring all this up because the expectation is, over the next few years at least, a couple of years for sure, we're going to probably have continued dysfunction. So that's in the 118th Congress. There's a division of power that still exists in Congress, as you all know. We've got divided chambers. Virginia Fox is once again the chair of the House Committee on Education and Workforce, right? So we've got the Republicans leading up the House with Bobby Scott serving as ranking member. And then over in the Senate Help Committee, we've now got Bernie Sanders, our Democrat, who is leading the Health, Education, Labor, and Pensions Committee on the Senate side. And your ranking member is Bill Cassidy from Louisiana. And, of course, those two individuals, if you know much about them, don't share a lot in common ideologically. So to quote the great Terry Hartle, who's the senior vice president and longtime GR presence at the American Council on Education, the HEA is likely to be reauthorized by 20 or 40, give or take a decade. And I think it's fair to say even more broadly that we just don't expect a lot of constructive activity out of Congress on the higher education front. So we continue to have the dysfunction, which means if this administration wants to advance its agenda, it's likely going to have to happen at the agency, executive agency, and sub-regulatory levels. So the Biden administration will almost certainly face increased oversight from the House now that Virginia Fox is controlling the House Committee on Education Workforce, and she's made this clear, great quote from a recent statement to officials in the Biden administration: think about investing in a parking space on Capitol Hill. You will be here often. Okay, but despite this increased oversight, our expectation, meaning those of us here at Thompson Coburn, believe the executive branch will continue to move forward aggressively with its regulatory agenda. So I think all the stuff we're going to talk about today, you're going to see it advancing in an aggressive way. By the way, if you can't tell, I'm a little under the weather. I apologize for that, so you may hear me pause occasionally, and that's either just off or to grab a little bit of water. Sorry about that. All right, so moving right along. The other thing I thought was important to understand is as this department is moving forward, it's important to understand sort of who's at the department. Now, the U.S. Department of Education is not a monolith, right? I mean, there are lots of different people over there, including at the policy and political level, and they don't all share the same beliefs. But it is fair to say that this administration has a much higher percentage of individuals within it whose backgrounds are not as educators or professionals in institutions of higher education, but who have backgrounds in consumer protection and enforcement. A surprising number of them actually came over from the CFPB. So Richard Cordray, who's now your Chief Operating Officer of Federal Student Aid, first Director of the CFPB, former Attorney General, Sartaj Alag. These are just a few examples. Senior Advisor, also from the CFPB, Kristen Donahue, Chief Enforcement Officer at Federal Student Aid, former Enforcement Director at CFPB. Bonnie Luttrell, Student Loan Ombudsman, formerly the Ombudsman at CFPB, and co-founder of Student Borrower Protection Center. Toby Merrill, the Deputy General Counsel, who was the founder of the Project on Predatory Student Lending. And I'm not suggesting these individuals are good or bad or that. My only point here is, when the department is in the process deciding policy and regulation, which is what we're talking about today, and all of the regulations that we've already seen and the ones that are coming, there's a group of people at the department informed by the White House and elsewhere, who are trying to decide what they want to do. And it's important to understand that there's a significant core group now at the department for whom consumer protection is a significant priority. And we're already seeing how that significantly influences some of this policy. And it's also important to keep in mind that these individuals who are interested in protecting consumers from harm are sometimes thinking about institutions as the harm doers, because institutions are the ones that are on the other side of that equation, and that also impacts their sort of policy approach. All right, so here's our first secret word. All right. Please, it is regulatory. I will say that out loud. Please select the correct secret word by pressing the appropriate radio button below, and I'll give you just a minute to do that. And while you do, I'll go ahead and grab a little bit of water myself. All right. So continuing on, with that backdrop, we'll talk about the status of the department's Title IV rulemakings. Now, Again, I want to give you a little bit of preamble before we actually get into what's out there. First of all, if you're interested in following all of this, much of it's available when the department is actually actively engaged in negotiated rulemaking, as opposed to, say, 10 or 20 years ago. They have a website where they put a lot of this information out there, and it's not, it's the drafts of issue papers, it's the issue papers, it's supporting documentation, arguments submitted by negotiators. I mean, it's really an incredible wealth of data. And it's all publicly available. So right now, the department, if you click on that link, you can go see all the information that was tied into their 2021-22 negotiated rulemaking. And I expect we will soon see a new web page that's focused on that, Greg, for 2022-23. I checked this morning. I don't think it's out yet, but I suspect it'll come along soon. The other place you can look, if you're a real regulatory nerd, like I am and like many of the folks I chat with on a daily basis, is the Biden administration's unified agenda. So this is if you're not familiar with it, a document in web form that is put out by the administration typically twice a year, and it articulates all the planned, ongoing, and recently finalized rules that are for each executive agency, right? So there's a page for the U.S. Department of Education, and it's a great place to get the very first sort of preview of what the department's planning to do. It also gives you a sense when we have rules like we do now, where they were negotiated, but we have not yet seen a proposed rule in the Federal Register. Sometimes you'll get indicators on timing in the unified agenda. All right. The other thing, before we get into the rules that are in play right now, I wanted to do was just take a minute here to talk about the negotiated rulemaking process. Now, I know many of the folks on the line have some familiarity with this, but I wanted to go through it for two reasons. One, it will help inform when we look at the rules that are in play. It'll give you a better context and a better sense as to exactly where those are in the process. And by the way, I want to emphasize that I'm talking about Title IV negotiated rulemaking, and I draw that distinction because the U.S. Department of Education is required to go through negotiated rulemaking when it negotiates and creates, or when it creates new rules that are carrying out Title IV of the Higher Education Act. To the extent that the department is enforcing or managing obligations that fall outside of Title IV, it is not required to go through negotiated rulemaking. And Title IX is a great example of that, right? And that'll be in our next section when we talk about the department's other rulemakings, right? So I'm focused on Title IV, but, not only did I want you to have some context before we get into where these different rules are, but I also really wanted to focus on impact points. We've had conversations with clients recently, and a lot of people reached out and said, well, there's all this negotiated rulemaking happening. How can we be involved? So on the screen, the gray boxes represent departmental responsibilities, things as part of the process that the department does. And the red boxes represent points through this process where an institution or a trade association or an individual, any member of the public, could get involved. And right now, we've got a lot of rulemakings that are in different phases. And so your opportunity to impact those rulemakings differs based on where they are in the process. And so I wanted to walk through this first so that when we walk through the rules in a few minutes and we talk about, categorically speaking, where each set of rules is in the process, you would have a sense of what you could still do if you want to be engaged. And I encourage folks to be engaged. I think, at the end of the day, the department's not going to know if you don't reach out to them. I mean, they've got special interest groups, there are lobbyists, there are trade associations, but, they only know what people take time to reach out and tell them, right? Apart from some of their own research, et cetera. But, I really encourage folks to take the opportunity if you feel like something doesn't make sense. Sometimes, by the way, the department just, and none of the advisors or anyone who speaks to them will necessarily perceive that there's an issue. And I'll give you a great example of this. During the negotiated rulemaking and the process last year around the change in ownership rules, which we're going to talk about in a few minutes, but one of the things the department was doing was tinkering with the definition of distance education. And they had proposed an idea where, as part of that definition, they would take the view that all programs offered by distance education were attached to the main campus. And by the way, the department's going to revisit this idea. They've made that clear. But, the notion was, and we saw the VA has done something similar, that sort of from a regulatory standpoint, from their end, we really think this is being driven for administrative reasons. They're trying to figure out a way to attach programs to campuses. And they said, well, for online programs, we want to sort of formally, through this definition, attach them to the main campus. But we had clients who offered distance education programs from additional locations of branch campuses to students in those states. And if the department were to require those distance education programs to be housed at the main campus, those students would lose state grant eligibility, because that eligibility was tied to the idea that they were enrolled in a school and program in their home state. And I don't think this had occurred to the department, and we and others raised this idea and said, we understand this is an administrative fix the department's looking to make, and there may be good reasons for that, but please understand that if you do this, if our program can no longer be offered from this additional location in one state, but has to be offered from the main campus in another state, then these students are going to lose their access to state grants. And I don't think the department knew that. And I think the only reason they knew that is because a handful of people took the time to understand the issue and to then send in information as part of the public comment period and elsewhere. So please, sometimes I hear folks question the value of interceding or engaging with the department and in the rulemaking process, and I will just tell you, I think it's extremely important. Okay, so let's talk about it. First, the department announces a negotiated rulemaking, typically in the Federal Register, right? And then they'll often hold some public meetings early on, and in the Federal Register they may say, we're thinking about negotiating these 10 items, our issue areas, and we want to hold some public meetings, get feedback, and they may do 2 or 3 of those around the country. And then in a subsequent Federal Register notice, typically after those public hearings have occurred, they'll sort of set the agenda, say these are the things we're going to talk about, and now we're soliciting negotiators. And these are the folks who are actually going to come to Washington, D.C., unless there's a pandemic, in which case they may be just on Zoom, and sit around the table, and they're going to take looks at draft versions of the rule and actually negotiate with one another in the department to try to come up with regulatory language. When those first sort of Federal Register notices start coming out, that is a great time if you are an institution or another stakeholder. You can coordinate with trade associations. You can participate in those public meetings if the department is holding those public meetings near you, or if they are virtual and you can sign up. Or you could nominate or serve as a negotiator. And we encourage folks to do that. We have seen a couple of situations where the department had trouble seating negotiators for certain groups where they had identified and said, we want someone at the table who represents this group or that group. We've also seen situations where negotiators were sort of selected at the last minute. But having informed individuals who care at the table is what this process is all about. So, if it's something you're interested in, that is a great way that you can participate. And, of course, you can support negotiators and help think of folks who might be good to sit at the table. All right. Then the department actually schedules the negotiated rulemaking sessions. Again, that typically shows up on their website or in a Federal Register when those are going to occur. And during the negotiated rulemaking, they'll circulate issue papers and draft language. So they actually hold these sessions, right? And there are typically 3 of them in recent years, and they'll hold them maybe like 1 in each month. So they'll do a session in December, January, and February, right, or something along those lines, and bring people together. And in between, they'll be issuing updated drafts or regulatory information for negotiators to look at. And negotiators will often be evaluating that, speaking with individuals in the sector or population that they are representing, maybe commenting on draft language. In some ways, it's become much more intensive in the last couple of years and rounds because the department's putting more information out during NEG-REG, and they're asking for negotiators to provide more information in return, meaning markups of regulatory language or memos or analyses explaining why they have the concerns that they have. So if you are interested and you are not actually negotiating, you can certainly support your negotiators in a wide variety of ways, either directly or through a trade association or assisting with evaluating information. You can review draft language and provide comments or feedback. For example, NICU had someone seated at the last negotiated rulemaking table, as is often the case. A lot of times the department likes for representatives from prominent trade associations to be at the table, and they were speaking with their constituencies, right, throughout the rulemaking process and gathering information in between rounds. And then the other thing you can do, sometimes the department, I want to be clear, I'm not talking about a different, the U.S. Department of Education during NEG-REG, around this phase, maybe during or after NEG-REG, but before a proposed rule comes out, they will allow folks to schedule listening sessions. And they were doing that last year. And so we held a couple for clients, and that's typically just an opportunity for you to call up the department or schedule a meeting and speak directly with them. And it's not really a dialogue, it's more of a monologue, but it's still an opportunity for you to provide your concerns or feedback directly to the department. Okay, so NEGREG gets done. And then maybe you've scheduled a listening session, maybe not. And during that period, if the negotiators during NEGREG achieve what's called consensus on certain language, then the department will take that consensus language and is supposed to use that. If they don't achieve consensus, then the department is sort of free to come up with what it wants to. But they'll have a number of different, typically, issue areas that they're sort of drafting to. And then they'll start putting out proposed rules. And you'll see the proposed rules show up in the Federal Register, and there's commentary in front of it, the preamble that talks about why they're doing what they're doing, sort of reflects on the negotiated rulemaking conversations, et cetera. Of course, this is one of the main opportunities, and the one that most people are most aware of, is to provide formal comments during the public comment period. And that's very easy to do now. The proposed rule shows up in the Federal Register, and then you can go online and you can just write your notes up or your comments in a PDF and submit it right there through the online portal. The department is tasked with reviewing all the comments that are received, and then it prepares its final rule. And it will send that over to OMB, Office of Management and Budget, and specifically IRA inside OMB. There's still opportunity for you at that point to have some impact, and that is you can schedule what's called an EO 12866 meeting with the Office of Management and Budget. It's also sort of like a listening session, but this isn't a listening session with the department. This is actually a listening session with the OMB while they are sort of sitting and looking at a rule and thinking about if they have any issues with it and talking with the White House and others. Finally, if they sign off, if it's approved by the OMB, then it will be published in the Federal Register. And at that point, about the only way you can impact that rule, short of a new negotiated rulemaking process, would be to challenge the rule through litigation. Otherwise, you're complying, right? Because now the rule is final and it becomes law. So you can see there are a lot of steps to this process, but there are also a lot of opportunities for institutions to engage, or individuals to engage in the process. One other thing I just want to mention, and then we will get to the rules. Title IV negotiated rulemaking timing, which is a little unusual. So there's this statutory language, and you can see down in the bottom right-hand corner we have the site for you. It's called the master calendar, and there's this thing, the master calendar requirement, that says essentially, in effect, that if the department it has to publish a final rule by November, and this is Title IV. I should be real clear. This is just Title IV rules. It has to publish a final Title IV rule by November 1st of any given year for it to become effective by July 1 of the following year. So this is why you so frequently see final rules from the department that come out October 28th, October 29th, November 1st, and why they all seem to become effective July 1, right? It's because the department's always working against that calendar. And if they fail to hit that November 1 deadline, I mean, theoretically, if the department published a final rule on November 2nd, it would take, almost 2 years before it become effective, right? Because it would be July 1, not of the next year, but the year after that, right, would be the earliest it could take effect. So that's a big reason why the department is pushing so hard right now, because, anything they can get done before this November 1st could become effective July 1 of next year. Anything they don't get done in final form by this November 1st, the best they could hope for is that it would become effective July 1 of 2025 with the presidential election right around the corner. So they are really hustling to get as much through as they possibly can. But this is a really important thing to understand when you look at the timing. When the department historically, sort of when you think about NEGREG on cycle, it tends to announce that it's going to do NEGREGs, towards the end of the year, and then it likes to actually hold the negotiated rulemaking sessions late in the year, December, January, February, tries to get proposed rules out in the spring, comment periods over the summer, then it's putting together final rules so it can try to get them in final form by mid-fall and no later than that November 1 deadline. And that tends to be sort of the NEGREG cycle. Right now, incredibly, we've got sort of 2 or 3 different cycles that are all happening on top of one another, which brings us to the Title IV rulemakings. So first of all, let's talk about the ones that are already done. There were two negotiated rulemakings that were announced in 21 and 22, and you had some rounds of neg reg that occurred in late 21, and those dealt mainly with bar defense and a lot of the discharge concepts. And then you had a second round of negotiated rulemaking that took place in early 22, pretty late, right? Because typically you like for your neg regs to be occurring in winter and like very early part of the year. And these got slipped a little later. And they dealt with a whole range of subjects too, change in ownership, 90-10, financial responsibility, gainful employment, lots and lots of topics. Okay. So then last year in the spring, the department kind of had to look at all the stuff that had been negotiated and say, what can we get to and what is going to have to punt until the following year. So what you're looking at on this screen, these are the things that they decided in 2022. This is the stuff we got to get done by November 1st, 2022, because we want it to be effective by July 1, 2023. These were the highest priority items for this administration is another way to think about it, right? Or at least the ones they thought they could get done by November 1st. Bar defense to repayment came out, and both bar defense to repayment, actually, this one came out on November 1st, and the change in ownership process and standards, I think it was October 28th that it hit the Federal Register. These are active links. The stuff under bar defense here on your screen, so you see it's an active link, all the stuff below it before you get to the next highlighted link, it's all part of that same one. And then if you go under change in ownership, you click on that link, it includes Pell Grants and 90-10 rule, right? So everything here is covered between these two links, and that'll take you to the federal registers. So these are all now final rules. Everything on this screen has been put out in final form and will become effective July 1 of 2023. So if you're in compliance or financial aid, or some other area at an institution that may be impacted by these rules, now's the time that you're looking at them and trying to, watch the webinars and read the Federal Register and look for the other training opportunities and make the changes you need to make so that you'll be ready to go on July 1st. And at the end here, when, we give some of the practical advice, that's what we're getting at. I'm going to talk about some of this stuff and maybe a practical approach to trying to get to this other than just poring over the Federal Register for weeks and weeks and weeks. The first, if you look at what's on the screen, breaking it into the big two buckets here, the bar defense, and by the way, Thompson Coburn, we hope to put out webinars over the next couple of months and training stuff that's specific to some of these rules, right? So this webinar obviously is just an overview of all the regulatory activity and where we are, but we hope to put out some training webinars that are very specific to some of these topics. Bar defense is the new claim process by which borrowers, students can assert that an institution did something wrong, and as a consequence, they shouldn't have to pay back their loans, and it's sort of what they would have to assert successfully and what the standards are to be successful and the process by which that decision is made. We're going to talk about that pretty extensively in the next couple of months during a webinar, but I'm also going to give you some thoughts about that later on today. And then the stuff that went along with that in the same rulemaking really, again, was focused on discharging of loans. So, under the bar defense rule, someone can discharge a loan by asserting successfully that their school wronged them in some way through a misrepresentation or omission of fact, et cetera. But there are all these other mechanisms that exist in the law that also can lead to a loan discharge. For example, if someone's in attendance at an institution or a branch or additional location and it closes. And I want to emphasize that point. I know a lot of folks see that title, closed school loan discharge, and they think, well, this would never impact us. I'm at State University X. We have 40,000 students. We're backed by the state. We'll never go out of business. But keep in mind that students become eligible for a closed school loan discharge even if you close an additional location. So if you have that, campus in Mumbai and it's just not working out and you've decided that you guys are going to close it in the next 8 months, this rule applies. Right? And theoretically, you could have some closed school loan discharge exposure if you're going to close that location before everyone graduates or withdraws. Or even if you've got folks who may withdraw within the last 3 or 4 months prior to closing that location. So closed school loan discharge, again, it's not just about an entire institution closing. It impacts any location closure, even if the institution itself is still thriving and continuing on. And there are lots of private nonprofit and state public institutions that have locations around the world and are making decisions responsibly to open or close institutions as markets change, et cetera. terminal and permanent disability discharge, false certification discharge, all different processes and mechanisms pursuant to which student loans ultimately can be discharged based on their underlying circumstances. Also, some updates to the rules impacting interest capitalization and public service loan forgiveness. And then right in between, I skipped over, as you all probably are aware, the department has, one administration to the next, sort of gone back and forth on the use of mandatory pre-dispute arbitration and class action waivers. They're really focused on enrollment agreements with students, and the Biden administration, like the Obama administration, has taken the view that if you have an enrollment agreement and it's includes a pre-dispute arbitration or class action waiver, you should not be able to enforce it insofar as a borrower is asserting something that would be deemed a borrower defense, a misrepresentation or omission of fact, a breach of contract, et cetera. But, it's interesting. The regulatory language has always been a little loose, and it talks about sort of the contracts with students for enrollment or for the loan, et cetera. And I think there's always been an open question, what if you had a contract with a student that wasn't an enrollment agreement but might somehow otherwise be entered into at the time of their enrollment? Would that somehow be covered? And, I could think of different types of contracts students might sign to, use a health facility or a dorm, or that might have a mandatory pre-dispute arbitration agreement. So it'll be interesting to see how all this plays out over time. All of this is now in final form, and if you want to take a look at those rules, you can click on the links, and again, keep an eye out. We've got training materials. I know others are producing training materials as well that will be quite good, I'm sure. But this is the stuff that's pretty well baked and that you're going to want to be getting up to speed on prior to July 1. Also, we expect there may be some litigation challenging some of these rules, and you'll want to keep an eye out for that as well in case it impacts their implementation. The other second half here was the change in ownership standards and rules, Pell Grants for prison education programs in 9010. These are pretty specific topics, so unless you are interested in a change in ownership or an acquisition, prison education programs or 9010, this may not be as significant for you. The only thing I'll just highlight is, our observation, our practice here at Thompson Coburn, we do a lot of merger and acquisition work in higher education. In general, higher ed, as many of you know, is contracting right now. And there are institutions that are struggling at some points with sort of vision and mission and enrollment, and maybe looking for partners. And we've seen in the last 5 to 10 years across all sectors an uptick in institutions that are interested in partnerships, whether that's to find a larger partner with whom to affiliate, or large institutions with capital that may be interested in partnering with someone smaller but that does something really interesting. At any rate, so, it's still a small percentage of higher ed overall, but there is an increasing percentage of institutions we think that are sort of thinking about transactions, and it is interesting that they are now running into these new change in ownership processes and standards as they try to complete those. Again, at the very bottom here, impact opportunities. Really, at this point, you're talking about complying with these rules and maybe monitoring litigation, because the only real option to challenge a final rule would be through litigation. Okay, so that was our first flight, or however you want to think about it. Now let's talk about the pending Title IV rulemaking. So this is stuff that is not fully baked, but that is in process. There was a proposed rule that just came out on January 11th regarding income-driven repayment plans. If you're interested, you can click the link and go take a look at it. And there is right now an opportunity to comment on that rule. So that was proposed rule, and the comment period is open. Interestingly enough, and I'll talk about it a little bit later, there was also a request for information that came out at the same time that had to do with identifying low-performing programs, which we think is pretty interesting. But we'll get to that in a few minutes. There are other proposed rules that are expected this April, so in 2.5 months, and some of them we expect to be really significant. And this is stuff that, if you're in the General Counsel's office, your financial aid folks and others, at least some of these should, folks should be prepared to review these carefully when they come out. one, to comment if anyone at your institution or they are interested in commenting, and to see if there's anything there that might be a problem, or even if they don't want to comment, just to be aware that this stuff is in play, because these are big topics. We're not talking about rulemakings that, are focused on discrete technical issues. We're talking about major concepts within federal financial aid, right? So gainful employment, I know that this is one of those things that a lot of institutions in traditional higher ed hear gainful employment and they think, well, that's a for-profit school problem. I will tell you, when I heard Terry Hartle about a year ago at a conference, he made the point that up one DuPont, there where ACE is located in Washington, D.C., they're pretty concerned about gainful. And I think the reason is because they and others are aware that there has been a lot of pushback on the department this cycle. Right, gainful employment, this is the sort of debt-to-earnings metrics that the U.S. Department of Education keeps trying to apply to certain types of programs and has successfully applied, and then, it was put in place by the Obama administration, it's stripped away by the Trump administration, and now the Biden administration has reintroduced it. And the notion conceptually is if your programs, if you're charging people too much or they're loading up on debt and they're not able, after they graduate, to service that debt, then your program's out of whack. Essentially, the debt-to-earnings ratio is not appropriate, and we think you should either cease offering that program or figure out a way to get it into alignment with the required thresholds. So there was a lot of pushback this cycle by a lot of folks who said, well, okay, even if you're not going to hold traditional higher ed and its programs accountable, and to the extent that those programs could lose eligibility, what is stopping the department from gathering that debt-to-earnings information for those programs and just making it available to consumers as part of a consumer information concept, right? So set aside the eligibility determination. What about just gathering this data and publishing it? And it is becoming harder and harder, we think, for the department to defend why they wouldn't do that. Because for a long time, the argument was, well, we can't make eligibility determinations on programs offered by traditional institutions because this magical language, gainful employment, doesn't exist in the statute and regulation for those programs. It only exists in the statute and regulation for the programs offered by proprietary institutions or certificate programs offered by the rest of higher ed, right? And, of course, then, like I said, the pushback was, well, we understand, then set aside the eligibility determination. If your point, department, is that it's important for consumers to know whether or not programs are a good financial value, you have the ability to gain or obtain the debt and earnings information for all programs offered by all institutions. Why wouldn't you just make that available? And what's interesting is there are folks on both sides of the sort of bipartisan divide that are kind of interested in this. I mean, there are Republicans, as you can imagine, who are quite interested in accountability, and this notion doesn't offend them making this information available. And there are folks in the Democratic camp, too, that, said, well, okay, I mean, if we can make it available, even if we're not tying it to eligibility determinations, why don't we? So the idea is gaining steam, and we think the folks in One DuPont know that. And if you're in traditional higher ed, I encourage you should be paying attention, because I think it's going to get harder and harder for the department to defend not extending this to all institutions of higher education. And if it does get extended to all institutions of higher education, what you're talking about is for every program that you offer, the department on a student-by-student basis for all the borrowers, gathering debt information and earnings information, calculating numbers for your programs, and making that information publicly available. That's a big deal. It'll be a really, really big conversation. So this is an interesting one to watch, gainful employment. Beyond that, I mean, ability to benefit is a smaller topic, but certification for Title IV participation, financial responsibility, and standards of administrative capability are big topics, right? And financial responsibility in particular for private nonprofits, I think, is one. Public institutions are deemed financially responsible by virtue of being backed by the state, but private nonprofits are not, nor are proprietary institutions. They have composite scores. They have other standards of financial responsibility that have to be met. And you may recall, and we learned this through the Obama administration, all institutions, including public institutions, were subject to certain financial responsibility triggers and reporting obligations, which was sort of a question mark if you were a public institution, since you're already deemed financially responsible by being backed by the state. Why do you have to, report the occurrence of certain types of triggers? And by the way, part of the reason is because nobody raised that question during negotiated rulemaking when the Obama administration was creating this rule. That's why. I think if public institutions had been louder at the table and said, well, wait a minute, why shouldn't we have a carve-out, maybe that would have occurred. That's not to point fingers at anybody. It's just to say, once again, I don't think folks really appreciated that they were going to be covered by those requirements, likely, until after this rule came out. And it was the Trump administration that actually interpreted whether or not they would be required, public institutions would be required to do all that financial responsibility trigger reporting. And they said, well, there's no carve-out in the law. So this is a good opportunity for you guys to engage and maybe try to raise that concern once again now that the Biden administration is rethinking this topic. And remember, we have not yet seen these proposed rules. So they're anticipated to come out in April of this year. That's what the department has suggested. And you will have an opportunity to respond in the context of sort of formal comments to those rules. Speaking of impact opportunities, so you may still have a chance to schedule a listening session with the department after the proposed rules come out. We haven't seen any announcements about listening sessions. Typically when they do that, they'll put something out on the wire, either in the form of an electronic announcement or in a Federal Register. Keep an eye out. You can certainly comment on the proposed rule once it hits, and after the proposed rule goes over to OMB, you could schedule a meeting with OMB, right? And then, of course, there's challenging through litigation. But there's still lots of opportunities the negotiated rulemaking piece is done for what you see on your screen, but there's still lots of opportunities to try to impact the final rule. These rules we expect will become effective July 1, 2024. You know, our expectation right now is that you'll see the proposed rule, like say in April, you'll have the comment period over the summer, and a final rule by October, November of this year. What about future Title IV rulemaking? So about 3 weeks ago, the department announced another slate, right? It's sort of like if you or your kids are Marvel movie fans, it's like, you know, you've had phase 1 and phase 2. This is phase 3 of the department's universe, right? The ED universe. So this is the stuff that hasn't started yet, but that the department indicates it wants to get to. They've suggested they're going to put out a notice of rulemaking, not a proposed rule, just a formal notice in the Federal Register this coming April, and indicating that they want to get at these topics. How do we know that they're already looking to do that? Because we looked at the unified agenda, which, remember, was the thing I showed you about 4 slides ago. And all of this stuff was listed in the unified agenda. And there was some press coverage, if you saw Politico or Inside Higher Ed or Ed Dive or any of those, where they talked about some of this planned rulemaking. July 1st, 2025 is the earliest we would expect any of this to become effective, right? Because the department, all that stuff on the prior screen, first of all, they're trying to, gear up to actually implement, monitor, and enforce the first slide, the stuff that's already become final and what becomes effective this July 1. Then over the summer at the same time, they're going to be looking at comments to the proposed rules that they are trying to get together and get published by this April, and then they'll be scrambling to review all those comments and put out final rules by this fall. So, with regard to this set of rulemakings, our expectation is that the department would be doing well to actually get neg regs started late this year. So after November 1, they get the notices out, they identify their negotiators, and then they actually set their meeting dates for, December, January, and then February maybe of early next year. And then we might see for this batch proposed rules, next April, right, with comment period over the summer and trying to get all this stuff done by November 1st of 2024, which means, again, July 1, 2025 is the earliest that it could possibly become effective. Lots of opportunities remain then to impact this rulemaking process. Coordinate with trade associations, whether for you that's NICU or ACE or CCCU or CQ, any of the bunch. Participate in public meetings, nominate or serve as a negotiator. You could support the negotiators, review draft language during the actual neg reg. You could schedule a listening session with the department. You could comment formally on the proposed rules, or you could hire a law firm to write comments for you, hint, hint. You could schedule an executive order 12866 meeting with the OMB, or you could challenge the rule through litigation. So you pretty much still have every possible opportunity to influence the formation of these rules. Now, if you're like me, you may be looking at this and saying, well, what is it exactly that the department plans to do with these rules? We've got 1 or 2 word descriptions. We don't have a lot yet, but we have a little bit, because when they put stuff in the unified agenda, they typically add a line or 2 about what they're looking at. So for accreditation and related issues, it seems like their focus is revisiting, in particular, the department's recognition of accrediting agencies. So, many of you know, some may not, that the department doesn't just regulate institutions directly, it also directly regulates, and there are regulations that oversee the accreditors that the department recognizes. So if you want to be a gatekeeper for Title IV, you have to comply with these regulations and be recognized by the feds. This was all considered just a couple of years ago during a very sort of intense and detailed rulemaking held by the Trump administration that came to consensus. And this raises an interesting point. So just 2-3 years ago, under the prior administration, there was a rulemaking that took into account accreditation, state authorization, and distance education. I mean, those were the big primary topics that were considered during that rulemaking. A lot of people, when they had those public hearings early on, said, this is just too much. There's so many topics to be covered here. The department should narrow it down. You'll never be able to get through a neg reg. And I thought there was a lot of sense to a lot of those comments, to be candid. And the department moved forward with the negotiated rulemaking, covered a tremendous amount of territory, and I think it's fair to say, to the surprise of many, and to the credit of the negotiators, they achieved consensus, which means, under that negotiated rulemaking, it meant that the negotiators all agreed to all of the language on every topic. Now the department has taken a different tack under the Biden administration, where if you achieve consensus on a single issue area, then they will deem that to have achieved consensus, and they'll run with that language. But it used to be, for many, many years at the department, that to achieve consensus, the department said, we're only bound if you achieve consensus on all the issue areas. And that doesn't mean everyone who was a negotiator was happy with all the language. As some of you have heard, and a wise person once said, if you have a compromise, a good compromise probably means no one's really happy because nobody got their way. I think similarly, when you have consensus across multiple issue areas, that probably means there was give and take, and nobody got their wish list. But it's still the case that these issues were visited very recently. These regulations were revised, and you had consensus language from 16, 17 negotiators. So what's fascinating is if the department now goes back and rewrites the regulations around these topics and does not achieve consensus, I think it sort of raises an interesting question as to what the degree of their mandate, in a sense, right? I mean, you had language that everyone agreed to, and now you've come back and revisited it, and everyone didn't agree to it, and you're moving forward with it anyway. And it, in my mind, at least, certainly weakens the department's position. And if, theoretically, if someone were to challenge those regulations, it would be an interesting point to push. But setting all of that aside, the department clearly intends to get back at this. And I think, the department's recognition of accrediting agencies has been and continues to be a sort of really political issue. And I think this administration's interested in going back and revisiting some of those recognition rules and tailoring them further. Let's see. For state authorization, I think there continue to be questions. A lot of folks are unhappy with, particularly sort of on the consumer advocate side, with the concept of state reciprocity, and there's a sense that, particularly institutions that are offering distance education across multiple states but are only authorized in one aren't as accountable as they should be. I think a big push by the consumer protection folks and advocates that are inside and outside the department around state authorizations to sort of revisit these rules and ultimately create a system that creates more accountability for those institutions, particularly operating in distance education context. And I think the definition of distance education is up for grabs. And I actually think the thing I talked about earlier, the department said when it backed off its proposed revision to the distance education definition that was part of the change in ownership rulemaking, it said in the final rule, we're going to come back to this. So at least part of what we think is going to be discussed here, again, is this idea of requiring the attachment of distance education programs to the main campus. Whether that means they're actually offered or emanate from that campus or just the department as a regulatory matter will attach them is hard to say. R2T4 we expect to be technical in terms of revisions. Cash management, similarly, although the department may decide to formalize or expand its ability to put institutions on HCM1 or HCM2 and the circumstances. My view is, having done this for, like I say, over 2 decades, I mean, I've always viewed cash management as something the department has the discretion to do. It can sort of flip the switch on to HCM1, heightened cash management 1 or heightened cash management 2 at its discretion, and we've seen them do that over the years. And for those of you who may not be familiar, I mean, what we're talking about is, for a typical institution in good standing with the department, typically you go to the department, you say, hey, we've got these students and they're eligible for this aid. Please give us the money and then we'll disperse it. And that's kind of how it works, right? But when an institution starts to run into issues or gives the department cause for concern, they may change the way that works. And they may say, well, how about this? You advance the cash to the students and then you come back to us and we will reimburse you. Right? And sometimes the department says, and we'll do that just based on a very little bit of information and can do it within 24, 48 hours. And sometimes they say, you're going to have to provide us a whole lot of information before we're going to reimburse you, and it can take 30 to 60 days. And so they're sort of changing the flow of those funds and how they flow, right? And our experience has always been that they have a tremendous amount of discretion already, but my guess is that they are going to look to formalize some of those practices and maybe formalize that they, state in a very explicit way that they have that discretion. Third-party servicers and related issues we think is terribly interesting and potentially significant and impactful. We think this goes beyond the department just thinking about traditional financial aid sort of third-party servicers. And we're going to talk about here in a minute, one of the big policy concerns for the department has been the increased outsourcing by institutions of higher education of a wide range of functions beyond financial aid, right, to bundled service providers and online program or platform managers, OPMs. I think the department is trying to think about ways that they can extend their regulatory reach to cover those entities. Some of them don't, in our view, presently qualify as third-party servicers under existing law and guidance. And we think part of what the department may be attempting to do here is to redefine what constitutes a third-party servicer such that they can extend their regulatory reach to cover a wider range of vendors that are currently providing assistance to institutions of higher education. And we're going to talk about that a little more in a few slides. Improving use of deferments or forbearances, again, probably more of a technical topic. And finally, the federal TRIO programs, which for those of you who are involved, is a great set of programs that help get people prepared for and into higher education. And we think the department is going to revisit. It's been a while since they've looked at sort of the eligibility and processes for the TRIO programs, and we think they're going to take a look at that. So let's talk about the status of the department's other rulemakings, and by that, again, we mean the stuff that's not Title IV, but that's still under the purview of the department. All right. So there's several, and they tend to be carried out by different divisions of the department. OPE, Office of Post-Secondary Education, is the one that manages most of the Title IV action. Office of Career Technical and Adult Education has a joint rule right now that's really centered around WIOA funding, and that final rule is already in progress. Office of Planning, Evaluation, Policy Development looks like an OPEID, but it's not really. It's an OPEPD. They are proposing to revise some of the rules that govern grant offerings and eligibility, and for a lot of traditional higher ed, for many of you, particularly large research institutions or others that may participate in some of these grant opportunities, you probably want to look at that. And it could be impactful for you, or it may be an opportunity for you to sound off. The department's also proposing here in April a new rule impacting FERPA, Family Education Rights and Privacy Act. The department has been working on privacy and I'll sort of roll in data security concepts now for the last 5 or 6 years, and many of those concerns, I think, have taken a backseat in this administration to the other regulatory priorities that we saw in the prior slides, particularly those that are sort of consumer protection driven, right? But I don't think the department's forgotten about privacy or data security, and we think over time they're going to come back around and get more involved. And FERPA, of course, is already the privacy piece, and we think the data security piece is coming as well. But I think if you went up to most folks and said, setting aside Title IV, what's the big sort of other regulatory package you're thinking about right now with regard to the Department of Education, you're probably thinking about the Office of Civil Rights. And it's the last bullet here, which is the new big Title IX rule, right? And these are long, long titles, and if you parse through all the words here, I mean, the first one is about non-discrimination on the basis of disability, the second's sex in athletics, and the third is sex in education and programs. And it's that third bullet, which is the real cornerstone here of this new push for updated civil rights regulation out of the department. The Title IX redo, or redux. On April 6th of 2021, this administration just right out of the gates announced that it would be overhauling the Trump administration's version of the Title IX rule. And then last July, we saw that proposed revision the department received. The last count I saw was, there's some question about how this math was done, but, a lot of comments, let's put it that way. It's 235,000 or 180,000 or, depending on how you count it, but it's a lot. And they're projecting the final rule here in May. Now, one thing I do want to highlight for everyone, and if you are involved in Title IX on your campus, you will remember this from the Trump administration. I talked about the master calendar earlier, and I talked about how when you have Title IV rules, the department has to get it out by November 1st, and the earliest it can become effective is in July 1st of the following year, which means, at a minimum, when you're talking about Title IV, institutions always have 8 months, at least 8 months, to review and get up to speed and try to implement rules. Title IX is not under Title IV of the Higher Education Act. It's Title IX of a totally different act, right? And what that means is the department can create an effective date essentially at its discretion, right? So if you recall, the Trump administration released its rule in the summer of 2020, and required compliance by that August. I mean, schools had, I think it was something like 8 or 9 weeks to try to come into compliance and adjust the rule. It was a short time frame, and that was probably a political reason that they did that. This time around, you may also see the department put into place an effective date that is on the shorter side. We think this is a major priority. I think they're going to want to get this rule effective and implemented as far in advance of the next presidential election as possible, is my expectation. So, I don't think they have quite the rush that the Trump administration had, where they had a presidential election right around the corner. But I do think that this administration is going to want to get this rule out there, and for other reasons beyond political. I don't mean to sound jaded and cynical all the time. They also, I'm sure, think this is a significant improvement and want to see it effective as soon as possible as well. So don't expect 8 months. We expect, if this thing actually hits this coming May, that you may have 2 or 3 months maybe to get effective and up to date on that rule. So you'll want to be watching for it. You want to be watching for all the different training materials and things that will come out, I'm sure, to help you get up to speed. Speaking of which, we did a webinar on the proposed Title IX rule and really went through it with a fine-tooth comb shortly after it came out last year. And this is available on demand. So if you want a preview, we think that new rule is going to hit in about 4 months. If you got 90 minutes, you can go and watch this, and it'll give you a pretty good preview, we expect, of what you're going to see in May. Also, after the last Title IX rule came out, we ended up doing this 6-part training series, which is really for administrators at campuses, also just free, sitting on YouTube, to help people get up to speed. And we expect we'll probably do something similar this summer after the new final rule comes out. So if you are looking for training materials and things along those lines, you are very welcome. And that's why we do this, to check this stuff out. Okay, that brings us to our second secret word. I did not put these together, but someone very cleverly chose pending, which I assume is a reflection of all those pending regulations that we've been talking about. So again, I'm going to take a quick sip of water while you guys tap the radio button that corresponds to the word pending. All right. So let's talk about sub-regulatory activity. This is the stuff that is not in statute. It is not being created by the agency pursuant to the Administrative Procedures Act and through rulemaking. It is stuff that they're just putting out there in terms of interpretation or policy at the sub-regulatory level, which means it does not constitute law, but it often is very impactful and certainly should not be ignored. So there's been an increase, and I'm trying to talk about things sort of thematically here. There are two or three things. I mean, the department's got all kinds of policies and sub-guidance and electronic announcements all the time, but I wanted to highlight two or three that I think are sort of significant and worth your time to watch. The first is this focus on online program managers. Lots of institutions right now have relationships with vendors that could be deemed either bundled services providers or online program managers, et cetera. And, many in traditional higher ed and a few also in sort of non-traditional career higher ed as well. And the department, there are folks outside of the department who used to be at the department. There are folks inside the department. There are folks up on the Hill who really do not like this outsourcing for a variety of reasons, right? I mean, the sort of standard line is they feel like this is, I think they feel this is something that institutions, the regulated entities, are supposed to be doing, and they are outsourcing them to non-regulated entities that are not as qualified and not, subject to the oversight of the Department of Ed and accreditors and others, and that is troublesome to them. Like most things, I suspect the reality is it's complicated. I'm sure there's some OPMs that are superb and do great work and others that aren't as good, as is always the case. But the point we want to make is this is something right now that the department is thinking really hard about, and it has been trying to get at these relationships in a number of different ways. In May of 2022, there was a Government Accountability Office report that was critical of the department's oversight of online program managers. We did a webinar on that prior slide where we sort of talked about that. It also talked about the incentive comp rule and how it plays into revenue sharing relationships between schools and online program managers, which is often how the economics work in those relationships. Shortly thereafter, in June, the House Education Appropriations Subcommittee released a report, and you can go to it if you click the link and you want to see the language that accompanied the FY23 appropriations, and it included some statements that were extremely critical. I've got one here for you just by way of example. The committee is deeply concerned by the proliferation of for-profit OPMs in higher education. Specifically, the committee is troubled by how tuition sharing agreements between universities and for-profit OPM companies can create perverse incentives that drive up costs, waste taxpayer dollars, and rip off students. In December, Democratic leaders, including Scott and Murray, so those are your two education committees in the House and Senate respectively, sent a letter to the department, so this is just, last month, reiterating these themes and emphasizing that the department has a responsibility to conduct proper oversight of the arrangements between institutions and OPMs. So again, this leads us to believe that the rulemaking related to third-party servicers may be the next effort to get at this, because we've seen the department. Here's what's interesting is, we've seen a lot of discussion around the incentive comp guidance that permits revenue sharing relationships to work in this space. And there have been those who think that this guidance that's out there should be rescinded because it is just guidance. It's not in the law itself. But rescinding it wholesale is problematic because there's so many students that would be adversely affected. So we've seen other avenues. The department, during the change in ownership rulemaking, tinkered with the definition of nonprofit. And in an early version of that rule, they proposed that on a go-forward basis, nonprofit institutions that had relationships with third parties that were on a revenue share basis might jeopardize their nonprofit status with the department, and they might be regulated as proprietary institutions. And of course, there was a lot of pushback, and that got dropped from the final rule. But what it illustrates is that this is something that the department has been thinking seriously about, right, for the last 2 years. And they've been slowly thinking about, they got the GAO report. There's been the efforts, on the Hill. They talked about redoing this definition of nonprofit. They decided not to go that route. We think the next way that they're going to move into this space is probably through the third-party servicer regulations. And so we encourage all of you who have significant OPM relationships, you should be watching this and watching it carefully. I mentioned earlier another place that is really interesting that the department is doing a lot of rethinking is around how they manage mergers, acquisitions, and restructurings. And in our practice 20 years ago, if you had said, well, what types of transactions are you seeing? I mean, it was always, almost exclusively occurring within the proprietary sector. And now I would say half of our transactional practice involves private, nonprofit, and public institutions doing different kinds of things, all different kinds of things too. I mean, there's a lot of variety in the transactions, but there is a lot of activity happening here now. And the one, remember we're now in the sub-regulatory section. I mean, of course, the department has formally rewritten its change in ownership rules, but at the same time, they are also rethinking their sub-regulatory approach and policies and how they think about and treat these transactions. And it's been really interesting. They introduced a new policy last year where they said when institutions go through recertification, we're going to think about whether there's a parent entity that should be required to guarantee the liabilities of the Title IV participating institution, even if it's sitting inside a subsidiary. Which, of course, when you think about the proprietary side of things, you think about parent companies and owners. But on the private nonprofit side, it makes you wonder about hospitals and churches and other organizations that may be sole members or controlling entities of institutions of higher education. And the department seems to slowly be working in the direction of wanting to understand where those relationships to exist. I had a department official tell me earlier, I guess last year in 2022, we were talking about nonprofit relationships, and I made the comment, well, when you have a sole member of a 501c3, that's not really an ownership. And the comment was, you will never sell me on the idea that the sole member of a 501c3 is not the owner. I'm going to treat that just like it's a 100% ownership relationship, which I thought was pretty interesting. And I understood the point. There was a recognition that it wasn't ownership in the traditional economic sense, but still it was being deemed as essentially the same for regulatory purposes. So a lot to think about here. The other thing the department is seriously rethinking is its application of certain types of restrictions in and around transactions and restructurings, including growth restrictions. And growth restrictions from the department perspective means, sort of restrictions or limitations on when you can add new programs or new locations and things like that, subsequent to or sort of in and around a transaction. So there's a lot of policy being developed and a lot of thinking occurring right now in and around mergers and acquisitions and institutional restructurings. The last thing I'll comment on, which is just fascinating to me, I made the point earlier that the department seems to be rethinking what its sort of gainful employment is really going to be about. And is it going to continue to be just about those two words, gainful employment, as they appear in the statutory and regulatory text and an effort to apply a debt-to-earnings metric specifically and primarily to proprietary institutions and certificate programs or non-degree programs offered by everyone else? Or is it going to be expanded beyond that? So on the same day the department released its new proposed income-driven repayment plan rule, which was January 11th, remember on a prior slide, it also published a request for information, quote, regarding how best to identify low-value post-secondary programs. It appears, though it is not certain, I've reread this several times, and I concede it is not certain at all, but it appears it could be a first step towards applying a debt-to-earning metric to all programs at all institutions. As I mentioned earlier, I don't think the department is on the cusp of asserting that all programs at all institutions have to satisfy a debt-to-earning metric or similar concept to be eligible for Title IV. But I think the department is inching toward calculating that information for all institutions and making it publicly available, right? And, the question would be whether I think the eligibility determination would still be restricted to those institutions that actually offer, quote, gainful employment programs. The language in the fact sheet that accompanied this release, if you haven't seen it, you ought to take it out and read it, but it's pretty interesting. And this is just an excerpt. In August, President Biden made clear that the administration will hold colleges accountable for charging high prices without delivering corresponding financial value to students. This includes publishing a list of the programs that provide the least financial value in the country. Today, as the first step in this process, the department is formally requesting public comments on how to best construct this list, including comments on which metrics and methodology should be used to determine which programs should come with warnings. The Secretary will request improvement plans from institutions with programs on the list after it is published later this year. I don't know. If you read the context in which this commentary appears, it is under a heading about gainful employment that references programs at proprietary schools. But, when I read this language, and what's interesting is in a subsequent paragraph, the department concedes. It says, we acknowledge there are some programs that aren't designed to prepare people for employment or to make money. And then they sort of say, we'll just have to figure that out. But that, again, suggests to me that they're thinking beyond proprietary school programs, because all those programs, by definition, are required to lead people to gainful employment. So if the department, in making this announcement, is acknowledging that there are programs that are not intended to lead people to any kind of gainful employment, it would seem that they are contemplating programming that is outside of that defined term. I don't know, but if I'm an institution in traditional higher ed, I would definitely be paying attention to this. And again, I think your advocates inside DC are doing so. So let's, I've overwhelmed you here over the last hour and 15 minutes with all of this regulatory information. And, this is just a short little presentation. I mean, over the next 18 to 24 months, it's just going to keep coming. So how can you approach all of this and make sense of it in a sensible way? I've got a couple of suggestions for you here. The first thing I would do is I would focus on affirmative obligations that are in the rule. I mean, somebody's going to have to sit down and read the rule, or read, NICU or NASPA or, somebody else's digest of the rule. But you're going to have to get someone familiar with the basic concepts. But then what do you do with what's in there? My experience is it's often that new rules come with new affirmative obligations, whether that's a policy of practice or some reporting requirement that has to be in place when the rule takes effect. My advice, first of all, is to identify those and consider that the low-hanging fruit, right? And there are a lot of things that come along with these rules, and the idea is if something bad happens, you could end up with a bar defense claim, or, if you have a low enrollment year, maybe you've got some financial responsibility trigger that has to be reported. But that's not stuff that's necessarily going to happen on July 1st. There are other obligations that, as of July 1st, you're supposed to be meeting. I would identify those first. Right? The things that I call sort of affirmative obligations. And I'll just give you a handful of examples in the rules that just became final, right, and become effective this July 1. So in all that bar defense stuff where it talks about the claim process, et cetera, the department also has reinstituted an affirmative obligation on institutions, all institutions. There's no carve-out for publics or private nonprofits. Everybody is supposed to be submitting arbitral and judicial records. And this obligation, and you can see the site down below. You ought to go check it out. I mean, it's really broad, right? And you're talking about claims and complaints and counter complaints and all this stuff in connection with any bar defense claim filed in arbitration by or against the school, or in a lawsuit by the school. But here's the key idea, or against the student, or by any other party, by the way. A bar or defense claim means, in effect, an act or omission that is or could be asserted as a bar defense. So this doesn't mean that a student has actually sued you and claimed a, quote, bar or defense. I mean, it means that they're suing you over something that could be the basis for a bar defense claim. So if you got a misrepresentation issue and a student is suing you or you're in arbitration, that is a claim that could be the basis for a bar defense claim. And my read is it is going to activate this reporting obligation. So this would include assertions, and here's the other thing. The department, because they've expanded what considers is the basis for a bar defense claim, it includes now misrepresentation, substantial misrepresentation, omission, breach of contract, or any act or omission that might give rise to a claim under state law. If that seems broad, it is. That's why. And in my view, it means as a practical matter, practically any claim that a student might make against the institution probably ultimately comes down to a misrepresentation or a breach of contract or omission or something like that. So, I think if you're taking this reporting obligation seriously, it's potentially going to require you to, at the least track all of this, understand how to report to the department, and understand whether you've got arbitration or litigation that might be covered. And if I'm a public institution, a state flagship, I mean, if I've got hospitals, you might have all kinds of little student issues that come up here and there. I mean, if you have 50,000 students, it just happens, right? I mentioned this to someone at NACUA earlier this year or last year, and their response was, well, we just don't comply with that stuff. So I suppose non-compliance is always on the table. But if you are interested in satisfying this obligation, which becomes effective July 1 of next year, I think it's going to mean that the General Counsel's office and the Financial Aid office and some of the guys are going to have to connect with one another and talk about how do you monitor for this stuff and ensure that you're complying. The department indicated, by the way, another important point, that they're going to gather all this information and put it in a centralized database and make it accessible to the public. So all those arbitrations and that litigation, if it is captured and you're reporting that, I mean, the department at least is suggesting that their intent is to make that publicly available. Now, we're a long way from that database being developed and published and put out there. But this is in a rule that takes effect next July 1. This is not being contemplated, right? I mean, this is in the law now. The agency indicated in the preamble that it will provide guidance to institutions on how to submit all this stuff, right, and where this centralized database is going to be published. So, your judicial stuff is already public, but the arbitral stuff may not be, right? Typically, a lot of times it's not. So pretty interesting development on that front. If you have pre-dispute arbitration, class action clauses in enrollment agreements or agreements that may otherwise be impacted, that's something else that would need to be cleaned up and ready to go by July 1. The other thing I wanted to highlight, your financial aid folks will know, but not everyone in the institution and general counsels, others may not realize that there's a regulation. It's 34 CFR 621 that outlines a whole host of information that, if it changes, has to be updated to the department within 10 days. And one of the things I wanted to highlight is the department, as part of its change in ownership rule that became final and becomes effective this July 1, they revisited this whole section. So this is all the stuff that, if it changes, you're supposed to notify the department within 10 days. It's a lot of stuff. Name changes, address changes, new locations, program measurement, decrease in level of offering, new Title IV administrator, that's like your director or corporate director or vice president of financial aid, whoever's in their system is the lead financial aid person. A lot of stuff. The stuff that they really focused on changing is in the red boxes. And, I can see most of that had to do with changes in ownership and control, right? Or then you've got that new eligible prison education program provision. But this is a good opportunity just to sort of dust off this provision and make sure that someone somewhere is aware of these obligations and that they are coordinated with, whoever in the institution they would need to be coordinated with to know if these changes are made so that they can satisfy these updating requirements. So again, this is the kind of thing, as of July 1, this stuff will change, and you're going to want to be ready to go because it involves a reporting obligation. Okay, here's our third secret word. Oh, appropriately, it is compliance. So please take a couple of seconds to hit the radio button next to the word compliance, and then we will continue to my last little piece of advice here. I know we've got 8 minutes left. By the way, I can hang on for a few minutes for sure to answer questions and see if we can get through some of what's come in during the presentation. Okay. Risk mitigation strategies. Now, some of this, for those of you who are compliance professionals or in general counsel's office, you may think, well, of course. But when you're just being, hit with all of these new regulations, again, I think it is important to sort of take a step back and consider how should we be moving through this in a methodical way to try to adjust and implement strategies given all the new stuff that's coming down the pike. So this is my advice. With new rules this administration is seeking, with a lot of these new rules, and we talked about the Consumer Protection Corps there, that's now over at the department. They're really seeking, at least in part, to increase institutional accountability and consumer protection. And what that means is we're getting rules that largely make it easier for the department to act in response to noncompliance and increase the range and severity of available sanctions. I have sometimes referred to this as making a bigger stick and making it easier to swing. This also produces rules that make it easier for students and third parties to bring claims against institutions. All right. So, if you have a claim that is brought against you eventually, whether it's a bar defense claim or a closed school loan discharge claim or, any of this kind of stuff, misrepresentation, omission, then, at that point in time, you'll circle up with your advisors and you'll try to look at the facts and, you'll learn the process and work through it. But the question is, what can you be doing right now to try to mitigate the risk of having to deal with that down the line? And, the obvious answer is think about the things that are likely to serve as the basis for a claim in the first place and try to figure out how you can prevent those things from occurring, right? So under the new law, there are effectively 7 bases upon which, for example, to bring a bar defense claim. I'm going to focus on bar defense right now for a second. Substantial misrepresentation, substantial omission of fact. And don't be carried away by the word substantial. Really all we're talking about here is a misrepresentation or omission of fact upon which somebody could reasonably rely to their detriment. That's really all we're talking about, right? Breach of contract, aggressive and deceptive recruitment tactics. Now, if you're like me, you may be looking at those, and the first question is, well, what does that stuff mean? So this is exactly my point. There are definitions of these concepts in the law. In fact, as part of revisiting the bar defense to repayment scheme, one of the things the department has done is it's gone back to the sections in the law that aren't, by the way, part of the bar defense framework. They're independent of that. I mean, they're just places in the law that the department administers where it just says, hey, schools can't misrepresent, schools can't engage in an omission of fact, right? And those can serve as the basis for a bar defense claim. They can also serve as a basis for a program review or just an independent action by the department. And one of the things that the department did when it revisited this whole thing is they went back to these definitional sections and they said, you know what, we're going to revise these definitions. We're also going to include a bunch of examples. That is, in a sense, a gift to institutions. Because what the department has done is it has said, look, we don't want you to misrepresent. Here's our baseline definition of misrepresentation, and here's a bunch of specific examples of the kinds of things we don't like. So if I'm an institution of higher education, my response is going to be, you know what, let's pull that stuff. Let's look at these examples that the department has been kind enough to lay out for us. It's not an exhaustive list. It's just exemplary, but it's still a pretty good list. And let's sit down with our admissions personnel and our recruiters and our vendors who are making representations to students and others who may be interacting with students regularly and making misrepresentations. And let's do some training. And let's say, hey, this is the kind of stuff that really gets under the department's skin and that you need to avoid. Some of these things, by the way, don't have to do with representations that are made directly to students, or some of them might surprise you. Like the department says, you know what, students should know who's providing your program, which is another shot at OPM relationships that they worked in to this substantial omission of fact. If you look in that new section of the regs, the department said, we think it's a substantial omission of fact if you're not telling students who's actually offering the program. So this is the stuff I would focus on. Don't get carried away with all the complexities of the claim process. If you ever get a claim, you can get into all of that. Focus for now on what constitutes a substantial misrepresentation or a substantial omission of fact, and build training materials and start teaching your people, right? So the department has revised and expanded subpart F to include specific examples of misrepresentations, including transferability of credits, course requirements, facilities, student services, admission selectivity, internship and placement incentives, all this stuff. They said this is the stuff that bothers us the most, right? Same thing with omission of fact. Also, they've got this whole new concept of aggressive and deceptive recruiting. This is a whole new subpart in the regulations, 34 CFR subpart R. And they've said, this is the kind of aggressive stuff that we don't like. So again, it's almost a gift. It's like they've given you your training materials, right? They created this new subpart and they said, this is the type of student pressure, prospective student conduct that we don't like. So our suggestion is, don't get hung up on the complexities of, legal standards and whether intent is required and how the claim process works. Just focus on understanding what it is the department doesn't like and teaching your people to avoid it. Leverage this detailed information. If you want to have a good compliance system, some of you have probably seen this before. It's informed by the federal sentencing guidelines and sort of what constitutes a compliance system. You got to have good policies. So use all that detail the department's given us and create new policies that make clear, that detail, create checklists, however you want to do it. Train your people on it, right? So they understand this is the stuff the department doesn't like. Then you have to monitor for noncompliance, and if someone goes off the reservation and engages in noncompliance, you have to be willing to enforce your rule, right? If any of these 4 pillars aren't there, your compliance system will not work. But right now we have an opportunity to start building these compliance systems and training our people and trying to mitigate the risk that is created by, candidly, a bar defense claim process that is not particularly friendly to institutions, right? So the best way to steer clear is not to end up with claims in the first place. The other thing that I would suggest is when you're looking at your vendor relationships, and my apologies to my vendor clients, but if I'm an institution, I would review my contracts with vendors that provide recruiting or marketing services. You could obligate them to engage in training with you and your folks. You could obligate them or seek to obligate them to indemnify you for violations of these requirements, et cetera. But there are a lot of ways you can work with and examine those relationships with your vendors. And then breach of contract. A borrower also can bring a claim if an institution has failed to perform its obligations under the terms of a contract. Now, the Obama administration stated during its bar defense reg that it deems a contract, this is in the preamble, to include, because here's the problem. For years, traditional higher ed avoided using enrollment agreements and contracts, and largely the court said, yeah, and we're not going to tell you what is a contract or what isn't. But that has started to change. And in the last 5 to 10 years, and we've really seen this in the litigation around, when students during the pandemic went online, courts have started to say, well, we think there is a contract here. And the department went so far in the preamble to that neg reg to say, hey, we think it's your catalog, it could be your bulletin, it could be any kind of representation or materials you potentially provided to a student. But if you're telling us you've got no contract, we disagree, and we're going to tell you what it is. So I just want to be clear to traditional institutions, private nonprofits, publics. I think the Department of Ed would absolutely take the view that you do have contracts with students, and a breach of contract is a basis for a bar defense claim. We've been talking a lot. I think the future we may see traditional higher education move in the direction of using enrollment agreements, because I think now it's becoming evident that it may, on balance, be advantageous to do it, right, rather than letting courts and agencies tell you what your contract is. And I think this is interesting to see what happens in the future. But one thing you can do if you have a contract with a student, or if you don't, but you've got materials that could be deemed a contract, is to go back through that stuff and make sure that it's legible, it's clear, and that you're not exposing yourself by making promises or commitments that you can't keep, right? Well-designed contracts that maximize flexibility for institutions will reduce the likelihood of breach of contract claims. And this is something else that you can do now over the next 6, 7, 8 months to try to start mitigating your exposure, to a breach of contract issue down the line. All right. So we have a blog, Regucation. We write about lots of different stuff. By the way, if you didn't see it, great. There was a Title IX update second half of last year where the department put out some new guidance around pregnant students, management of pregnant students on campus. We write about stuff like that all the time. It's free. Subscribe. We would love for you to check this stuff out. That's why it's there. Similarly, this webinar and all of our webinars are available on demand on our website, and we would love for you to check that stuff out as well. We do have compliance materials, white papers we put out periodically. I just want to highlight a couple of these. The first one of financial responsibility reporting. So that law has not changed, but that's one of the proposed rules we expect to see in April. All the financial responsibility triggers and what has to be reported. It will probably be final later this year. When it is finalized, we will update that white paper and recirculate the checklist. And then similarly, the last one on the far right here, maintaining compliance with the 90-10 rule for the proprietary schools out there. We are working on an updated version of that and hope to release it soon as well. And finally, our disclaimer, we're not your attorneys unless we're your attorneys. So let's look at questions. We have a handful, and I am happy to try to see what we can get through here. I'm curious if these presentations will ever be worth credit for certified compliance ethics professionals. I don't know, but I'll look into it. I've had a couple of folks also ask about accounting. I don't know how frequently we could get to the accounting, but we might be able to get to the ethics occasionally. So I will absolutely look into that. Let's see. Is the reduction in legislation that became law a result of the increased number of bills presented or an actual decrease in the bills being passed? Well, the statistic is fewer pieces of legislation that are being introduced are actually becoming law. So there has been an increase in the overall number of pieces of legislation over the last couple of 3 decades that have actually been introduced by a couple of 3,000, I think. But as a percentage, fewer things are getting across the finish line. Part of that may be because folks on the Hill are more and more frequently using legislation. A lot of legislation is introduced that no one expects to become law. It is really just a way of a particular congressperson sort of setting out their views on the matter. And, they're trying to move things in a certain direction. So it's not that they expect that specific piece of legislation to actually become law, but, it's helping to sort of set the boundaries, right, and start to move things in a certain direction. And sometimes you'll see several people introduce legislation that all have sort of the same idea, working towards something that a committee or someone else will put out. So, it could be an increase in that practice, but my read on this, and this is informed by a lot of conversations with a lot of folks who are much smarter than me and spend a lot more time thinking about Congress specifically, is that it really also significantly reflects a reduced ability to work together to get things across the finish line. How do you become a negotiator? This is a great question. So for negotiated rulemaking, the department will put out, I mentioned earlier, typically in the Federal Register, they'll say, we want someone to, we've got like 12 or 13 classes of individuals, and some of these are dictated to them in statute, but they'll have, financial aid directors, nonprofit institutions, proprietary institutions, public institutions, accreditors, state regulators, et cetera. And they'll say, we need someone to sit at the table and represent this group of people. I was a negotiator once, and the group I represented was general counsels and compliance professionals in institutions of higher education. So, And what typically happens is the trade associations that represent those groups or others inside the Beltway or elsewhere will start to have conversations. They'll say, well, they're asking for someone. So like NICU, for example, they're always looking for private nonprofit negotiators. So NICU and some of the other trade associations that represent a lot of private nonprofit institutions of higher ed will start to get together, and they'll start to vet names and talk about it. When you see one of those notices go out, if you think, you can make by the way, you can make a nomination directly to the department. You could just send in your own, and the department will tell you like what you should send in and who you should send it to and what it should look like. You could nominate yourself if you wanted to. You could campaign for a nomination if you wanted to. But most typically, I think the way it works is the folks who are interested are reaching out to those trade associations and saying, hey, I'm interested in this, or the other way around, the trade associations are saying, we need a negotiator, this has been announced, and there may be 5 or 6 or 10 people that they're sort of have in mind, and they'll reach out to those folks and say, hey, would you have an interest? But if you see an announcement go out and you think it's something that you would like to do, I would suggest trying to identify which trade association or associations you think may be participating in that conversation and reaching out to them and letting them know, hey, this is something I would like to do, and getting your name on the list, so to speak. But I will tell you, I've done it once. I've been involved 2 or 3 times. I personally believe it's an extremely meaningful process. You don't always get your way, right, by any stretch, but it is a real opportunity to, help make the sausage, so to speak. And I do think it matters, personally. I really do. We have seen evidence of changes that occurred because negotiators, made certain points or were involved in certain conversations. Let's see. Do you know if the negotiated rulemaking sessions will be virtual or in person? Also a great question. So the first time they were in virtual was under this administration. They weren't even live streamed. In fact, the negotiated rulemaking I participated in, we spent the entire first day debating whether it should be live streamed, because that was the first one where that had ever come up, and that was several years ago. I think they are going to try to get back to in person. This is what I have heard, but I do not know for certain. Maybe that's been verified. I'm not sure if it has or not. But I do think there is a lot of folks that I've chatted with, I believe, are of the opinion that there is something lost when it occurs in a strictly virtual format. There's just, when you're in person during these negotiated rulemakings, folks are having side meetings, they're getting together for breakfast, and not just the like-minded folks, right? It's a great opportunity for folks who maybe are not like-minded to step off to the side and try to work something out. And when you're in a strictly virtual format, it's very hard to do that. I think it becomes more of like a series of speeches in a sense. So it's my personal hope that the department and others will move back towards in-person negotiating. Can we anticipate potential relief or improvement to any of these regulations if there's a change in the White House in 2024? How quickly can these be reversed or changed? Well, I suppose I won't speak to improvement because that, probably depends on your view of the world. But I do think that if you have a Republican president in the White House, in the next administration is a Republican administration, I do think that administration will likely revisit a lot of these rules. In at least recent years at the U.S. Department of Education, this is obviously a generalization, but, there have been, just as this administration had a higher percentage of people who came from a consumer protection background, the Republican administrations tend to appear to have a higher percentage of people who come from sort of an industry background, meaning they worked at institutions of higher education. And I think that just changes the attitude and outlook towards, what policy priorities should be. And as those changes occur, I think even setting aside some of the harder arguments here that have occurred from one administration to the next, just more generally, it's just a general view on how things should be done. Unfortunately, right now, the last three administrations, we've seen pretty significant swings in the regulatory tactic taken from one administration to the next. I thought the Trump administration's agenda was extraordinary, and the Biden administration has managed to top them. My talking point, which many of you have heard me say, is unfortunately I think this is the real losers here are the regulated community, meaning institutions of higher education and the folks you serve, because every 2-3 years you have to ditch your entire regulatory framework and write all new policies and implement all this new stuff and do all this new training just to have it scrapped 18 months or 2 years later. And that's a lot of resources being burned to accommodate the regulatory pendulum. But to answer the question, I certainly expect if you have a Republicans take the White House during the next administration, that you would see a different attitude at the department and a different sort of viewpoint on how policy should be carried out. And you probably would see revision to a lot of these same regulations. And some folks would probably consider that improvement. Others probably would not. Let's see. Do you think SARA is at risk with the state authorization rulemaking? What do you see as the impact to institutions of higher education with SARA approval and the proposed rules regarding state authorization? I think this is a great question. The good news for SARA, I think, is that they have strong and informed advocates, both at NC SARA, the folks over at WICHE as well, and the State Authorization Network, who really understand these issues and are trying to, in a meaningful way, inform the folks in D.C. Those of us who have been around more than 5 or 10 years remember what it was like before SARA existed. It was miserable. It was good work for lawyers, I guess, but it was miserable trying as an institution of higher education to educate across the United States. I think that is a powerful policy concept that is fairly simple to understand and still resonates. I think there's a reason that so many state legislatures were so quick to sign up and adopt SARA. It's because people understood the problem. And I think it would be problematic for the department to take a position that would totally destroy SARA, right? Just because the concept makes sense, it's powerful, it's fairly easy to understand, and it has worked. But the countervailing argument, of course, is, this lack of consumer protection, lack of access to, a lot of the AGs in a lot of states feel like SARA undermines their ability to protect their consumers, et cetera. And, those aren't bad arguments either. I think it's going to be really interesting. My gut is still that it would be going too far to do something that would totally destroy SARA, but I could see regulatory change that might make SARA less effective or more difficult to administer, or might increase the burden on institutions incrementally. I don't mean unsubstantially, but just incrementally. So, not all the way back to we're dealing with every state individually, but, there might be something between where you are now and that outcome. That I could see. So I think this is a hot topic. It's going to be really interesting. I think it's going to be one to follow, particularly if you're at an institution that offers a lot of distance education, and who doesn't these days? Even if you consider yourself an on-ground institution, most of us have classes that are offered online. I just want to make sure that I heard you correctly earlier. The Department of Education can delegates some of its authority to a third party that is outside the reach of Congress's oversight. The Department of Education can delegate some of its authority. No. Yeah, I understand what this is about. This is going back to the online program manager. No, the Department of Education is concerned that when institutions of higher education, I think this is where this is coming from. The Department of Education is concerned that when institutions of higher education outsource critical functions like designing academic programs and hiring instructors and communicating with students to an online program manager, the department and others, again, the department's not a monolith, but, some inside the department and some outside the department who are, in the space talking about these things, their concern is what's happening is that an institution of higher education is essentially outsourcing critical functions to a third party that is not under the regulatory authority of the U.S. Department of Education, right? And so that's the concern. Sorry. Okay, let's see. Will we be able to get the recording of this emailed? I think we'll email a link. Absolutely. I'll double check with my producer to make sure that we get something like that out the door. I think we do that, though. I think afterwards you guys will get an email that shows you where the final webinar sits on our website. You can go back and watch it at your convenience. Let's see. Do we review schools' contracts? Yes, I appreciate someone asking that. That is a big part of our practice. We regularly review contracts for our institutional clients of all types, whether it be with other institutions or with vendors, et cetera. Let's see. Someone asked if we reached consensus when I was a negotiator. No, I appreciate that question, though I did everything in my power to get us there. Let's see. How do we find or access the compliance white papers? Those are also located on our website. But you know what? If you will email me which ones you're looking for, I'm happy to send you the ones that are current. And I'll also let you know, again, there are a couple that we're updating. There's just been so much regulatory activity that we have pulled down a couple of them, and we want to update them. And when we do, we typically will do a blog post and announce, and include the fact that we've got a new white paper, and it'll be available in the Regucation section. All right, one more question. My producers are all waving their hands at me. Let's see. If we have a potential breach of contract today, will we have to report it to the department? Oh, that's interesting. Yeah, so the question is effectively these new reporting requirements, will they be looked back? I don't know yet. Historically, when the department has introduced a new requirement like this, typically if the litigation or the event that has to be reported is ongoing as of the date that the law took effect, you would have to report it. If it has been concluded prior to that effective date, typically no. But I think it will, we'll just have to look and see, what exactly the department tells us in the guidance. Hey, thanks everyone. I so sincerely appreciate everyone for tuning in. I know it's a lot to keep track of. I wish you the best in the coming year. If you have questions, give us a holler. And keep a lookout. Like I said, we do expect to produce more content in the coming months relating to some of these specific regulatory packages that are on the way. Otherwise, be well, and we'll see you next time.